Submission to your Lordship may kindly come to para number 12 of your Lordship's order.
Sir, the initiation of the matter is the magistrate has passed one cognizance order. You found fault with that cognizance order. 1 second, please listen.
Yes, yes.
If you want to seek a set aside of that order, what you should do, should not ask the magistrate to recall. You should file a quash petition seeking the setting aside of that order. You have filed a quash petition seeking a direction to the magistrate to recall her own order, which
Yes.
is not permissible.
Your Lordship.
Try to understand.
Yes, yes, Your Lordship.
Simplest terms, you
I
can
will-
just file a petition. You can amend this petition also seeking to set aside the cognizance order taken by the magistrate. That is okay. But you are asking for a direction to the magistrate to recall her own order, which is not permissible. Try to understand that.
With due respect to your Lordship's opinion, I placed a citation of Honorable Supreme Court of
That
India.
citation also is in my favor,
No, Your Lordship.
not your contention.
Kindly,
Please go through.
kindly come to
Yes.
come to page number 12 of my petition, Your Lordship. I have not sought a direction from this Honorable Court to the magistrate to recall its order.
You have sought that.
No,
You
that
read
is
your
my
prayer in
prayer.
the petition. You read your prayer in the petition.
It is therefore, in the light of judicial order of Honorable Divisional Bench in WPSR so and so, dated so and so, it is most humbly and respectfully prayed to direct the Land Special Judicial Magistrate of first class, come excise, come fifth additional magistrate, come fifth additional junior civil judge, Rangareddy District at Lilinagar, to strictly follow the law reiterated by the Honorable Supreme Court of India in criminal appeal number so and so between MS versus State of Uttarakhand, another Krishna Kumar Warrior versus Sherab Shope, dated 3/5/2010, in criminal MP number 552 of 2025, in FIR number 497 of 20, in PRC number 53 of 20 of Police Station Saranagar, in respect of alleged offences 417, 323, 506 IPC, falsely applied against A22 FI with true letter and spirit while deciding the criminal. I am not seeking a
1 second.
So now,
Well, 1 second, sir.
Your Lordship.
That means one criminal MP she has already decided. You want to direct her, want me to direct her to decide it again. What does it mean?
Decide it in accordance with the law of Supreme Court. Kindly,
Once she has disposed of the order, right? Once she has disposed of one criminal MP, how can this court ask her to sit in review of her own order?
Your Lordship,
magistrate
kindly
does
come
not
to
have that
page number
power.
8, kindly come to page number 18 and 19 of my
Yes.
criminal petition.
Criminal petition, आइएगा. Petition itself, original petition. Page number?
18, Your Lordship. The binding precedent of Honorable Supreme Court of India, I need not to demonstrate that under Article 141 and 144 of Constitution. The appeal has been filed against the impugned judgment and order dated 14/5/2019 of the High Court of Delhi, whereby the petition filed under Section 480 CRPC by the petitioner herein has been dismissed. The appellant herein is an accused under Section 415, 420 IPC, in which summons have been issued to him by a court at Delhi. He challenged the summoning order on the ground that it is only the court at Bombay which has jurisdiction to try and entertain the complaint. His petition under 482 CRPC challenging the summoning order has been rejected by the High Court by the impugned order. Hence, he is before us in this appeal. The Honorable Supreme Court, at para number 5, in our opinion, in such cases where the accused or any other person raises an objection that the trial court has no jurisdiction in the matter, the said person should file an application before the trial court, making this averment and giving the relevant facts.
Right. Right.
Whether a court has jurisdiction to try entertain a case will at least in part depend upon the facts of the case. Hence, instead of rushing to the High Court against the summoning order, the concerned person should approach the trial court with a suitable application for this purpose, and the trial court should after hearing both the sides and recording evidence if necessary, decide the question of jurisdiction before the proceeding further with the case.
Right.
So, this is the judgment of Supreme Court, wherein the summon order can be challenged before the trial court itself. This judgment of Honorable Supreme Court of India, which is binding on this Honorable Court under Article 141, as well as the public prosecutor, was not considered by this Honorable Court in its order.
No. If you are sitting on the same point, I must pass another speaking order, that's all.
Yes, Your Lordship.
Because you
I-
cannot ask this court, the purport of your earlier prayer in the petition
Yes, my prayer is
goes in
limited.
that way that I should ask the magistrate to redecide another, the same petition.
No, Your Lordship.
One petition she has already
Yes, yes.
disposed of. Now you are asking her to sit on the same.
It-
No review.
No, Your
or,
Lordship. It is not.
appeal
It is not my prayer.
No.
If this honorable court passes a order to dispose my criminal MP in accordance with judgments of
No,
Supreme
no,
Court
no.
only.
That criminal MP is already disposed of. If
Yes.
it is pending, I can ask them. Once it is disposed of, she cannot now decide in another manner.
That is not the law laid down by
No,
Supreme
no,
Court,
no.
Your Lordship. Your Lordship,
Please try to
moreover,
understand.
one more submission, Your Lordship. One more submission. And this honorable court, the APP also failed to represent before this honorable court with regard to the DVC SR number 208 of 2020, DVC number 16 of 2023, filed by me at page number 111 of 120.
Right.
So in this regard, I invite the attention of learned APP to the judgment recent. Now, today I filed, Your Lordship may have a judgment citation memo. Citation memo.
Yes. It is
Page number 89. Their Lordships of Honorable Supreme Court of India. Time and again, this court has emphasized on the courts the need to pass reasoned order in every case, which must contain the narration of the bare
Sir,
fact.
my suggestion would be simple enough. You file a quash petition asking me to set aside the order passed by the magistrate. That I can do, and then she will take another cognizance order
But the Supreme Court of
on
India,
merits.
the
But you
Supreme,
can't ask me to ask the magistrate to review her order.
I am not asking to review
You
order
have,
from, no, Your
Your
Lordship.
prayer is that.
Dispose of my criminal MP in accordance with the Supreme Court. If
the
this judgment
same
is not
criminal-
applicable,
The same criminal MP, she cannot decide it again.
but Supreme Court
without
says,
setting aside the
but
order.
Supreme Court giving liberty to me to file a petition instead of rushing to the High Court. Your Lordship, may kind.
The order can be set aside, then she can pass another order. Without setting aside that order, how can she pass another order, sir? Even the Supreme Court has set aside the order and then asked her to pass another order. You are
No,
not
no,
seeking that prayer.
18 and 19, the judgment, Your Lordship may kindly once again, whether a court has jurisdiction to try entertain a case will at least in part depend upon the facts of the case. Hence, instead of rushing to the High Court against the summoning order, the concerned person should approach the trial
Sir,
court.
what is the order you are challenging? What is the criminal MP filed under which section you just see?
210.
210.
Yes.
210 is meant for what, sir?
210 for taking cognizance.
Yes.
Taking
You please
cognizance.
go through. 210 is for taking cognizance.
Yes, Your
She
Lordship.
has passed the order under section 210. Now you want me to give a direction to the magistrate
When that is the question of law.
under section 210 itself in the
Yes,
same
yes,
MP.
implied powers. Your Lordship may kindly see Sakiri Vasu judgment I filed with my citations today.
Please go through. Go through.
This honorable, every court has implied powers, incidental
Please
powers.
go through Sakiri Vasu and tell me the principle laid down.
Hmm? Page number 26 of
Hmm.
my IA.
You are not going to the, yes, 26.
IA.
Yes, IA.
It is well settled that when a power is given to an authority to do something, it includes such incidental or implied powers which would ensure the proper doing of that act. In other words, when any power is expressly granted by the statute, there is impliedly included in the grant even without special mention every power and every control, the denial of which would render the grant itself ineffective. Thus, where an act confers jurisdiction, it impliedly also grants the power of doing all such acts or employ such means as essentially necessary to its execution.
So you know the facts of the case?
Facts of the case will not constitute the judgment.
1 second.
Yes, Your Lordship.
It is based on the facts and of the case only a principle will be laid down. So in this case, inquiry by the Air Force Authority was conducted. Two levels of inquiry was conducted, holding him guilty. That the accused, the victim committed suicide, but not due to the harassment of the office bearer. Then they came with a petition to order for CBI inquiry. That was rejected by the High Court. And the order of the High Court was upheld by the Supreme Court, saying that the concurrent findings of the inquiry authorities in the department cannot be found fault with. They are empowered with such, that is the paragraph you have read just now.
But my humble submission as for
Don't correlate any other paragraph to this.
My humble submission to this honorable court is, I have incorporated Article 141 of the Supreme Court of India at page number 2 of my citation memo. I may permitted to read out. The law declared by Supreme Court shall be binding on all courts.
Right.
But not the facts.
All of us are bound, even you.
Yes,
Right.
Right.
So,
But
210
the facts will not take away the power of any
Right.
court, stating that. Furthermore, the honorable Supreme Court recently at page number 31 of my
Sir,
citation.
my suggestion,
Page number
please
31.
follow, that would rectify your this thing and you will get the relief wanted. You can just ask the prayer to set aside the order, cognizance order.
One more,
That will do good for you.
one more submission, Your
If
Lordship.
you want to prolong the issue.
I am not prolonging. I am exercising my legal right conferred by the Supreme Court under its Article 141 powers, Your Lordship. Your Lordship may kindly see the judgment of Supreme Court at page number 11 of my citation.
Yes. Raghunath Sharma.
No, Your Lord. Raghunath Sharma. This is the MA Satyendra Kumar Antim.
Chudandi.
Page number 9 of
Page number 9 of
citation memo.
citation. bundle and
Today's citation. రాలేదా ఈరోజు మార్నింగ్.
రాలేదు.
So in this
చెప్పండి మీరు సత్యేందర్ కుమార్
Satyendra Kumar until the Honorable Supreme Court of India held that Mr. S.V. Raju learned AGS very fairly states that the public prosecutors are bound to bring the correct legal position before the court and the CBI will issue direction to the public prosecutor in this behalf. In fact, we are of the view that all prosecuting agencies, state governments, UTs should issue such direction to the public prosecutor so that neither in pleadings nor in arguments is a stand taken contrary to the legal position initiated by this court.
Right.
So in this case, what happened? The Honorable APP has stated that under section 210 of the CRPC, the court has no power, whereas he suppressed.
The magistrate court has no power.
He stated, but the law laid down by Supreme Court of India in case of Krishna Kumar versus Sher Shape, despite
That's
receiving
what
this.
you read. That is with regard to jurisdiction, sir.
Yes,
This is with regard to a cognizance order.
the magistrate court,
its
my humble
cognizance
submission
order.
is the magistrate court has no jurisdiction to take cognizance of 376 IPC
So
as
you
well
can't-
506 IPC as held by the Honorable Supreme Court of India judgment in SLP 648 of 2019.
So you simply seek that setting aside that cognizance order.
That is another issue, Your Lordship, but the duty cast on APPs, prosecutors to submit correct legal position,
Yes,
and the
that
law
is
laid on, he suppressed the DVC filed by me, the documents are not mentioned before this honorable court, and moreover, the illegal intimacy, which was the copy of newspaper clippings and remand case of the defendant complaint, Mr. G. Raj was all not brought to the notice of this honorable court by the APP, Your Lordship. Your Lordship, I most humbly submit, considering all my averments in the main petition and this IA and the judgment filed by me, a reasoned order may be passed, Your Lordship.
It's not numbered.
Yes, Your Lordship.
It's not numbered. It came up to uphold the objection or rule out the objection.
Your Lordship may kindly see.
For orders of the court, it is posted today.
Yes, the
Yeah.
Honorable Supreme Court recently.
Sir, you want redressal or you want to just go on?
I want to implementation of Honorable Supreme Court of
Yes,
India
please,
judgments.
I request you to do the same. You implement the orders. Don't go against the orders. The statute itself is binding on us. Please go according to the statute. 210 does not empower a magistrate to
Kindly
revoke
have a
this
look
order.
at Raghunath Sharma versus State of Haryana judgment.
Please go through. Please go through.
Page number 22, Your Lordship. Sorry, page number 23, Your Lordship. Para number 14. At the end, we may record our surprise that the High Court adopted the course it did without reference to the well-established position of law as demonstrated above. We summarize the findings, issues, directions as below. The bar under section 362 CRPC is almost absolute. The only exception to the bar which would then permit the invocation of inherent powers would be if it is necessary to meet the ends of justice.
Right. You please go through the para number 11 and 12. They have discussed elaborately the power under 482.
But they have concluded
One
it.
second. In this case also, a compromise was recorded between the parties. One of the parties has violated the terms. They came up in 482. The High Court has quashed. The Supreme Court has found fault with the said order and set aside the quash order.
Yes. But as per my understanding, as per para number 14 says that Supreme Court of India says that
You can't
the
just
power of
accept-
law laid down by Supreme Court is
Law
binding.
laid
Facts
down,
are not binding, Your
you
Lordship.
You should understand, not fact. The principle laid down is.
This is the principle.
482 has to be sparingly used.
Yes, Your
Yes.
Lordship. This is the fit case.
Yes.
This is the fit case to meet the ends of justice in this case for non-consideration of Supreme Court judgment.
You have now, right now, read paragraph 14, is it not?
Yes, Your Lordship.
What is the paragraph 14? It is a continuation of paragraph 12.
Yes, but
What
they
it
are.
said, it's what it said.
But this
The
is
High
the
Court adopted-
conclusion drawn by the Supreme Court.
That is what?
Hmm.
A conclusion drawn saying that High Court was wrong in setting aside.
In that case, but in
In
my
this
case, this court can exercise the power. Even if Your Lordship is.
You want to rely on the judgment, but you don't want the
Facts
principle
are-
laid down.
This is the principle, Your Lordship. As
That
per,
is the principle, that was.
see, in Sakirivasu also, the principle laid down by the
Sir,
court
I
is
can't-
followed
I
and the
can't-
petition was dismissed, Your Lordship. Your Lordship is well aware.
Precedents are here to follow, not to dissect them and follow a different precedent which is
That's
not
why-
laid down.
That's why the Supreme Court
Yes.
recently held that
Yes.
immaterial consideration cannot be taken to disregard the citations. I also filed that judgment also, Your
No, no,
Lordship.
no.
My humble
You are-
submission to
you are
Your
going
Lordship
on
is
a wrong.
the serious
formulation of
prejudice would be
principle.
caused to the petitioner if this honorable court did not consider my submissions.
If you want to take my suggestion in a correct perspective, your problem will be resolved in just 2 minutes, not such a lengthy argument is also required. Only you can
My-
seek for setting aside the cognizance order that is permissible in law. I can't ask the magistrate to exercise power which is not permissible.
I am
To
not
pass
seeking
another
to,
order under 210 is not permissible.
as per the,
We can
if
take
that is the position,
cognizance.
Your Lordship may consider the Krishna Kumar judgment and reason order may be passed. Krishna Kumar judgment says that the person can approach the same court.
Same
Your Lordship-
court for want of jurisdiction, sir,
Yes,
not for
that
want
is-
of cognizance order.
Yes, my challenge before the trial court is the trial court has no jurisdiction in the light of the judgment that 376 and 5 knots cannot be together be taken cognizance. So it exceeds its jurisdiction. So Krishna Kumar judgment is also squarely applicable and the judgment of 654 2019 is also squarely applicable.
Heard the petitioner counsel. Yes, anything to submit, sir?
Once a cognizance order is passed, that any order it cannot be recalled or reviewed except for correcting the clerical errors or arithmetical errors. That is the settled law. Even without jurisdiction or non-application of mine, that has to be challenged under inherent powers of this honorable court. You could set aside that order, but no direction can be given to the magistrate to reconsider it.
will
By
not-
setting aside, this honorable court can set aside that and to reconsider.
And again.
But the magistrate
today-
cannot
today
reconsider.
Absolutely, he
there
will
is-
not submit the order of Satyendra Kumar until he
Satyendra
will not
Kumar-
submit the order of Krishna Kumar. Routine mechanical
Okay,
submissions
now-
before the courts.
You do one thing. You have already submitted few citations, is it not, which is not placed in the bundle? You
Yes,
come
sir.
up with all the memo of citations.
Citation from my file, Your Lordship.
It's not there in the
Okay,
bundle.
obliged.
Today morning you filed, is
Ah,
it
yes,
not?
sir. Yes, obliged.
Post it on Monday.
Obliged.
Bid to represent G. Raghu, my lord. Lord, Lordship.